You're listening to The Trial Lawyer's Handbook, a courtroom preparation podcast series brought to you by Holland & Knight. This series is hosted by litigation attorney Dan Small. Listeners of this series will gain a fresh perspective on how attorneys can address various trial preparation issues and set themselves up for success in and out of the courtroom.
In the last episode, we introduced the farmers' export grain elevator disaster. 18 people were killed in a grain dust explosion that destroyed a 20-story concrete tower. There was no terrorism, no high explosives, no intent on anyone's part to kill and maim. It was an accident, pure and simple. But as Oscar Wilde famously said, the truth is rarely pure and never simple. If an accident was predictable, even arguably foreseeable, was it really an accident? Murder is wrong, everybody knows that. It's a crime and always has been. But other things that may be wrong have not always been so clearly viewed as criminal. White-collar crime, we talk about all the time now, but it's a relatively recent vintage. Until not so long ago, the common view was that criminals were ruffians, not men in suits and ties. Health and safety was one of the slowest areas to change. Traditionally, if a health and safety case made it to court at all, it was a civil lawsuit brought against the corporate entity or entities responsible. In most instances, that really meant the entity's insurance company. What this also meant was that the managers on the ground at a place like Farmers Export, the people who were most likely to have seen, to have ignored, or even to have directed the problem, and who were most likely to be able to keep it from happening again, were several layers away from any litigation. In the months or years it takes a case to wind through the system, the managers on the ground would be back at work, the incident a distant memory. As a force for change, litigation was often far too remote. In 1970, there was a major shift. Congress passed a law creating the Occupational Safety and Health Administration, or OSHA, and introducing criminal penalties against individuals for serious violations that caused death. That meant jail for a real person, not just payments from a distant insurance company. However, as with many new laws, there were few cases brought. It was too new, it was too different. 10 years later, the Department of Justice decided that the law was on the books for a reason, and it should be used carefully and judiciously. But how do you convince busy prosecutors around the country to try it? The department's criminal division decided to create a unit of attorneys specializing in these health and safety cases to support local prosecutors in the field. 1 year out of law school, I became part of that unit. Almost every case we brought was a shock to the defendants. Okay, maybe someone screwed up. Maybe they should have been more careful. And certainly it was a shame that someone or many someones died as a result. But no one meant to kill anyone. Is that really criminal? The Department of Justice and OSHA wanted to get people's attention. In many cases, it worked. So when 54 people died within 5 days in the 2 large grain dust explosions that December, OSHA came to the Department of Justice and basically said, we have a problem in the grain elevator business, and whatever we're doing just isn't enough. The department and the U.S. Attorney's Office in Houston, Texas, agreed to open a grand jury investigation, with our little unit providing support. The investigation itself was a surprise to the industry. Grain elevator employees and managers, company executives, and even government regulators were being summoned to testify before a federal grand jury and questioned by Department of Justice attorneys. But the real astonishment came when the 2 top managers of the Farmers Export Grain Elevator were indicted individually for criminal violations of the OSHA Act, with potential penalties including fines and jail. The world had changed. It was time to reassess health and safety in the grain industry in a whole new light, and maybe far beyond the grain industry as well. The law looks at each case individually, as it should, but sometimes the law and all those involved in it can and should be a force for change. Clearly, change was needed here. Maybe, just maybe, litigation could be an answer. We'll talk about this case and the trial in the next several episodes.
Thank you for listening to the Trial Lawyer's Handbook, a courtroom preparation podcast series brought to you by Holland & Knight. For more information on courtroom preparation, please email dan.small@hklaw.com or visit hklaw.com/Daniel-Small.